research, analysis, and very strong communication to push out those messages to whichever audience, to whichever, whether it's policymakers, whether it's the general public, or whether it's, in the court of law. And I think these opportunities that we want to support, and which I think we're all part of this very fortunate network of powerful leaders like Aisha herself and Zishan and Rubina and everybody else that's working together to make this a not just build up your research skills, but also to add to the body of knowledge with real experiences on the ground, as well as the rigor that your research brings. I'm really delighted that we have this opportunity, again, because of COVID, that we're being able to use technology to, perhaps do more sharing than we would otherwise be able to. I think that you should not feel shy when you're presenting. You should, use this as an opportunity to really practice on stage as if you're doing it in the real world. And with that, I really wish all of you luck today, and I look forward to, listening to what each of you have to say. Thank you.
Thank you so much, Ms. Sophia. Yes, indeed. We should utilize this time for more productive activities, and of course, the Asia Foundation has always helped us in, for the education sector. Your role is tremendous. Thank you so much. Now, I would like to invite and introduce Mr. Zishan Ali, advisor for rule of law and team lead for ADR at the Asia Foundation in Pakistan. He's a lawyer by training with over 12 years of experience and has provided legal advisory services to NGOs, INGOs, Government of Pakistan, UN agencies, ADB. Mr. Zishan is a graduate of Punjab University and holds a master's degree in law from Loyola University, Chicago School of Law. It's always a pleasure listening to Mr. Zishan. Thank you, Zishan.
Thank you very much, Aisha, for the generous introduction. As always, it's always a pleasure talking to you also. Despite you calling all of us to work on Sunday, it's a great pleasure to work with you and your team as well. Thank you, Sophia, for expounding on the thematic areas of research, women empowerment especially, and the foundation's tangible and eloquent approach towards the women empowerment and development of females as as leaders of change, as agents of change. So I would be very brief in the best interest of time to mainly talk about the project, give you guys a brief overview of the project. So we started working with the Kinnaird College for Women in Lahore in September 2016, and we talked about developing some specialized course curriculum for LLB students undergoing the law, the legal studies and the admitted law school at Kinnaird. Back then it was just an idea. And I remember the lengthy discussions Aisha and I had together. We talked about rolling out the program, designing the course curriculum, involving students, ensuring the buy-in. And it just feels like yesterday. I mean, it was a difficult journey to embark on, but I think it wasn't impossible. And it has been a very enriching and fulfilling experience working with your colleagues and working with people, especially Aisha Justice Jalani, who also happens to be part of your board at Kinnaird, and Justice Nasra. So all of those erudite legal scholars had immense and tremendous contributions to make while we were designing this program. Now today it's there. We already have the full semester program in full force. It's running. The structures is up and running. So briefly, here would like to talk about not only the research projects, but also the steps that we are trying to take at this point to further, the skills that we tried to develop in the important area of mediation and negotiation under the project alternative dispute resolution to these students. So I think, as Sophia rightly pointed out, so it's very important to, in fact, start talking about the skill set and the capabilities, the faculty that you need to develop as practitioners of law, as mediators, as negotiators. And taking a step forward, now we have this research project going on, and so as a next step, we'll be working with the other partnering law schools to develop some specialized program. For example, the mediation clinics, the moot competition on mediation and negotiation. So we are already discussing it, and also would like to train the graduate students on the important skills that you need to acquire to be a better mediator. So talking about your emotions, for example, so as a mediator, you need to learn how to control your emotions before the emotions start controlling you. Uh, your interpersonal and your communication skills are also very important at the same time when you conduct the on-site mediations. For example, if I may ask you, what is the opposite of talking, right? So it should be listening, to the best of my understanding, right? Uh, but the thing is, there are people who would say, well, it's waiting to interrupt, because my point of view is more important than yours. So, I mean, you talk about and you're thinking about a rebuttal in your mind. So that's not listening, right? And similarly, you got to have an understanding. And if you are, let's say, not listening properly, you're not understanding. Because most people don't listen to understand. They listen to reply, which is not listening, because you're not paying attention. You're not paying attention to resolving the dispute. And the best way to understand and to be understood is to listen. So, I mean, the list goes on, but these are some basic skills and qualities that a mediator should acquire before entering the professional, area of practice or starting to work as mediator. I will be available throughout the session in case you have any more questions. Happy to share more about the work we do with different agencies, with partnering law schools, especially with judiciary. So thank you very much, everyone. I think I will hand it over to Aisha before I run over the time.
Thank you so much, Sujan. And yes, you have pointed, very right points, and like what is important characteristic and criteria to be a mediator. And yes, I think normally in our society, we consider that the opposite of talking is waiting to interrupt. That's what we normally do, because the moment somebody starts talking, and then we start having rebuttal and refusals in our mind that how we are going to depart anything which the person is saying. So yeah, thank you very much. As you have mentioned that Nadra Hassan Law Department has started a major course on mediation. We try our best to inculcate certain activities and exercises during the course, where we try to teach students that your body language matters, your rephrasing matter, your words matter. Sometimes you are saying something which has a negative impact, and you can just reshuffle the words or rephrase your sentence, and the impact is totally different. Your body language, if somebody is speaking, you're not making eye contact, you're just looking around. So all of these things we try to teach students, and normally I think as a lawyer it comes into advocacy skills as well, that how you have to make other person understand your point. But as a lawyer, I think the only thing which we grew up with, and our students also agree to this, that we have been taught to, and we have been taught to practice litigation. We have been taught to litigate. We have less concept for the dispute resolving concept. We don't have that. We have that every dispute has to be solved by litigation. So you're very right. It is really important to change the concept of new generation, and new lawyers, the young lawyers, they should come up with another, with a strong alternative of the litigation. And as I always say, that ADR should not be alternative a dispute resolution, but the most appropriate dispute resolution mechanism. So yeah, thank you so much. I'm going to talk about the importance of research on mediation and its impact on academia. I am teaching right now legal research and writing as well. So my students who have started this course from me, they have heard it like 1,000 times. I keep on saying this like a broken record, that research is really important. And for research, what is the most important thing is that you have to read. So what is the impact of a research on academia? Knowledge, whenever you come to a law school, your goal is to attain a degree, but or a certificate or a diploma or any piece of paper. But is that piece of paper giving you knowledge? Is that knowledge sustainable? I have a quote to share with you that is by Mary Louis, who is the director of UNESCO Forum on Higher Education, Research and Knowledge. And she says that knowledge generated by research is the basis of sustainable development, which requires that knowledge be placed at the service of development, be converted into applications, and be shared to ensure widespread benefits. So whatever education, whatever knowledge you are getting at your law school, I think it should be sustainable, it should be shareable, and it should be having certain widespread benefits. Whether you are in your first semester or in your last semester of law degree, everyone tells you, including myself as well as your teacher, that advocacy skills are important. Your public speaking skills are important. You have to have writing skills. A lot of time my students face this issue that I keep asking them, oh, restructure this sentence. The sentence is not correctly structured. So you have to network to be a good lawyer. You have to have excellent critical analysis skills. Yes, all of the skills are important, but the most important skill is the research skills what you acquire. Knowing the law, I always say it is important. Of course, it is important that you know the law, you memorize statutes, you memorize acts, you memorize clauses, that's perfectly fine. But how to find a law, that is the basic key to success, in my point of view. Because knowing the law, that's fine. You know that, okay, this is the case and I can consult the constitution. But, as you keep on solving, all of the law schools have this teaching methodology to include propositions and case-based studies. So when you are studying case-based propositions or cases, then you actually identify that one case is not, you're not going to solve the problem or solve the case by consulting only one statute or one act. So it is a consolidation of a lot of laws, a lot of acts, a lot of judgments. So finding the law is the most important thing. So how you are going to have this habit develop or ability develop to find the law is the research. What do you do with the research? I really would like to have certain, your comments in the chat box. If you have questions, if you have comments, please keep writing in the chat box so I can, refer to them as well. But what is the research? Whenever I ask this question, a lot of times I get this answer that research is to read, to find something. Yes, to find something is a correct answer, but research is a process of identification of researchable problems. Whenever, we have students over here, we have faculty, whenever we have identified a problem in a society, wherever we have identified a material gap, we come up to solve that problem. So a lot of times students come up to us and say that, okay, on which subject or topic should I research? We always ask them to look for their own interest. And then after identifying your own interest, you have to narrow down that what basically has not been worked on in this particular field. And then you identify your research problem and your research problem, and then you have certain steps to solve that problem. And what are those steps? When you identify your and collect the material, when you have the right information. And how you're going to have right information? When you know about the steps of being informed. I was just sharing in the morning at some other platform that when I did my graduation, when I graduated in law almost like 2 decades ago, we only had library. So we used to go to the library, we used to, search through that catalog shelf, and then we had to go to the particular shelf and then to find the law, to find the book. So normally people never place books at the right, at the right shelf. So we used to spend the whole entire day in library just to looking for the books. Okay, this is relevant, this is not relevant. For today's students, I think every information is just a click away. You are just going to Google and everything is there. So there is a difference. A researcher or just a Googler. Because on Google, you find a lot of information, but how you're going to identify which is authentic and which is not authentic is when you are well read and when you are well aware regarding the authenticity of your source. So people who have studied from me or who have been doing this research, for some time, they are aware of this concept that authenticity is really important when it comes to your research. You have to have a theoretical framework, and that theoretical framework is going to put you in a role of a problem solver. So first you identify the problem, then you narrow down the problem that which has not been researched on, and then you try to have a theoretical framework regarding that. So we do have a question. What are the most credible sources for research for law, as there is so much opinion analysis and database? Yes, you're right. As in the start, I just told you that technology is a blessing and a curse as well, because then, it puts you in the shoes that you have to search for, authenticity. Then you have to have an eye for the authenticity of the resources. So I always give you a filter kind of a thing, that the first step is that you have to go towards the site, whether it is a government supported site or it's a blog. You have to, that's the basic filter we normally apply on authenticity. What is academic research? What is academic writing? We are talking about academic writing. So what is an academic writing? I would like to have your input as well in the chat box. But academic writing, normally we say that it is by the scholars for the scholars. So we call it legal scholarship as well. We do write for other scholars. Academic writing is devoted to the topics which are of interest of the academic community. Academic writing should present the reader with informed argument. So whenever you are making an argument, it has to be informed argument. This is what academic writing is. Why it is important to research in academia? Students learn a lot of skills when they are researching. They learn to identify a problem. They learn to reach to a possible solution. They develop a point of view on a specific topic. They learn to put up questions the way you people are doing right now, that, if somebody is giving his or her point of view, you have certain questions to put up. You have you have critical analytical skills to question the arguments the other person is putting up. Importance of research in law can never be denied. And relating to particularly mediation, the thing we are talking about, and why we have published this journal on a particular topic of mediation, is that chaos and conflict are basically part of your society. You just can't deviate from it. You are a lawyer. You're aware that you have this dispute resolution concept. Mediation is much needed. I have told you the importance of research in academia, that it is so important. It generates question, it generates debate, it generates brainstorming. Students who are involved in research have analytical skills. They have, they have these skills to put up questions. They have skills to question the arguments of the other scholars. Mediation is important, and research is being carried out on mediation now. For I think for past 7 to 8 years, we start hearing this concept. Well, it is a very old concept and phenomena, but we have started hearing it for past 7 to 8 years. Why research on mediation is needed? Because we all know that our courts are jammed up by the number of cases. We have repeated adjournments. Then we have concentration of litigation as well. One advocate, one lawyer has like hundreds of cases. So where is the quality? And then all the students of law, they are normally prepared for litigation. It is important to research, particularly on mediation. Why we've been focusing on ADR, why we have been focusing on mediation, because it's the less explored area. And with the passage of time, with the increased research on mediation, now we can see a lot of articles, scholarly articles and books coming up. So I always persuade my students to research on the areas which are less explored. Why? Because then you are building your subject expertise. So it is important. Also, people have no such awareness. A lot of people, we have an idea, mostly people have an idea what mediation is, but what are the advantages of mediation? That is something we really need to work on, and we really need to spread the awareness. This concept has a lot of, enough room for development of new models and framework. Well, research on mediation has impact, has a great and magnificent impact on academic writings. But still, there is a lot to research on and a lot to write on. Less research areas means less competition. So yes, this journal was the first step to inculcate the interest of research in our students, particularly mediation, and to make you a subject specialist or subject expert. When you're working on a less explored area, you become a key contributor, and you can develop that course. So as we see that mediation is the time for coming generations, is the time for the coming models under judiciary. So I think it is really important that law students start working on this concept, and you should be working as not to become a litigator, but a mediator. Eventually, you are going to be a dispute resolver, a dispute, conflict solutions is the basic concept behind. And with the passage of time, during recent years, research on mediation has increased and has helped in developing the framework at the governmental level. It has helped in making and strategies, responsive strategies for the policymakers and the other stakeholders. So it is really important to work in certain area which is less explored. For example, somebody was asking me that, oh, what should I write on mediation? What basically, I can give new concept to the reader. People are really intrigued. They know about mediation, they know about the success rate of the mediation, but probably they don't know the process of mediation, the steps of mediation, what is being experienced by the parties, what happens in a mediation room, what is the dynamics of a mediation step. So there are so many things we can explore on. There are so many things we can work on. Research is always very, dynamic and has diversity. So it is really important for us who are now working to change the system, who are working to have a transition from the litigation to the mediation, that we should work on it, we should research on it, and reading is the key to everything. uh, yes, we are going to take questions at the last, but yes, there are so many questions. So let's listen to our contributors to this journal, and let's see that what they have in their mind, what experience they would like to share about their research findings, about their limitations, and then we are going to take these questions one by one, because we will be joined by worthy speakers and esteemed panelists, in few minutes. So I think we should, as I've just given a brief outline that how research has impacted the mediation concept, and how and why we should work and research in this field. I think we should move on to our students, the contributors to the journal. Do we have Ms. Atika?
Yes, ma'am.
Assalamu alaikum, Atika. Atika, please introduce yourself and tell us something about your research paper, which was your research report and for your degree, and and share with us your research findings and why you chose this topic. What were your research findings and what limitations you had, and why you actually, because I still remember, because I was your supervisor in this paper, and I still remember that you were quite clear from the very start that you want to do research on mediation. So please share with us your point of view.
My name is Atika Shuja, and I'm a recent graduate of the Nadra Hassan Law Department at Kinnaird College for Women. The reason that I chose to work on mediation for my research paper is the fact that it's something that's quite out of the box, meaning thereby that disputes and clashes are resolved in a far more easier and speedier manner, and you do not need to get into those lengthier processes of adversarial litigation, which actually takes so many years to get the disputes resolved. I mean, people die and the litigation passes on to their successors. That's how slow and uncertain it is. So when Miss Aisha was teaching us ADR, she used to make us perform certain classroom activities apart from just the theoretical aspect in order to improve our negotiation skills. And at that time, I thought it's quite an interesting field in itself and something that should be explored more. Mediation is relatively new in Pakistan. So if lawyers and legal experts start working on it, and it becomes a trend and more people start opting for it instead of litigation, it would actually lessen the burden on courtrooms. So that is the reason I decided to work and research on mediation. Moving on to my research paper, which was actually my thesis, the research report for my final year to get my degree. So what my research paper is basically is about is the concept of ADR and how it has emerged over the years. I've particularly focused on mediation in my research paper. Many ADR mechanisms have evolved over the years, which are being commonly used nowadays. Many countries have also adopted these mechanisms as part of their local laws in order to improve their judicial instruments, which include arbitration, mediation, negotiation, conciliation, settlement conferences, neutral evaluation, parenting coordination, mini trials, etc. And I've explained them all in detail as well in my also discuss a legal regime worldwide. Talking about access to justice, um, it's important to note that the first and foremost prerequisite for justice to be served is treating every person equal in the eyes of law, no matter who he is and where he belongs to. So mediation and access to justice are quite closely linked. I'll tell how. Now, there's an essential characteristic of mediation that it provides the parties with the right to self-determination and autonomy. This right is that adds on to the element of access to justice, and that is a this is a particular feature of mediation that distinguishes it from adversarial litigation, hence making it one of the modes of ADR. Mediation has been for long considered to be a means for the provision of an easier access to justice, taking into account the fact that it is contrary to the adversarial litigation processes normally carried out in courtrooms in the world. The exclusion of lengthier procedures fixed by the courtrooms makes it easier for the public to uh, access justice, which is comparatively difficult to access otherwise. So consequently, mediation helps to lessen the burden in courtrooms. Talking about the burden on courtrooms, I've also discussed how mediation serves as a tool for limiting the burden on courtrooms. Since mediation is a form of ADR, it requires a negotiation process outside of the courtroom, whereby parties can have a healthy conversation with each other and they can compromise and reach some conclusion. Frequently using these ADR processes and normalizing mediation would eventually lead to settlement of disputes in a quicker manner without the need of going to the courtrooms. And this would actually save the time of the courts, and they would be able to better focus on complicated and complex cases requiring considerable time and emphasis. So talking about a mediation in Pakistan, there are quite a few laws that provide for the option of mediation, where section 89A of CPC is of considerable importance. Then we have the small claims in minors courts ordinance of 2002. Section 14 of the respective ordinance puts forth the concept of amicable settlement, whereby if at any stage of the proceedings it appears to the court that a matter is capable of being settled via alternate mechanisms, the court may refer it for arbitration, mediation, or even conciliation. Now, this ordinance also introduces the concept of salis, who's someone who performs the same duties as that of an arbitrator, mediator, or a conciliator. There's another act, the Industrial Relations Act of 2012. It, under that act, industrial relations disputes can also be dealt through mediation. Also, I've talked about the importance of confidentiality in mediation. Confidentiality plays an extremely important part in the success of mediation. In Pakistan, the process of mediation is confidential in nature. The court strictly considers such proceedings to stay confidential, and the failure to do so is considered as a breach of confidentiality. Then I've also discussed the structure of mediation in Pakistan, that how certain steps have to be taken by a mediator, including initial contact with the parties, scheduling the time and date with the parties, and then briefing the parties, and so on. Mediation centers have also been established in Pakistan. And looking into the statistics, we can see that Chakwal has a success rate of mediation more than any other city. The total number of cases which have been sent for mediation in Chakwal are 577, out of which 261 cases were such that were settled, and they reached a conclusion via mediation. Lastly, we've also discussed certain recommendations by considering models that other countries have been using to improve their mediation-related processes, which include formation of the public legal education information programs, establishment of special tribunals, free of cost mediation for the underprivileged, and mediated settlement conference programs. So that is my research on mediation. So other than that, I would like to add a bit about the limitations as well, as Ms. Aisha has asked me. So while researching on mediation, I would say that there definitely is quite a lot of gap in research, since quite a lot of resources are not provided to us. And in order to fill this gap, I think certain steps must be taken that cover practical aspects, such as visits to ADR courts, arbitration centers, training workshops should be held, and most importantly, access should be given to students so that they're able to have an in-depth knowledge of what they're actually studying.
Yes, very true, Arpita. Limitations, of course, we all are aware about the limitations that resources and access to the mediation courts and people who have been practicing a mediation was a little tight and was a little tough for us at that time when you were doing your research. But yes, you have very rightly put a lot of things and your research findings as well, that and you shared the success of Chakwal. And so yeah, success rate is there, you're right, and we actually require to move more and more towards it. I'm not going to take up a lot of time because we have our other speakers as well. Our other contributor to the Law Journal is Ms. Ummat Shafkat. And the first badge of Nadra Hassan Law Department, we always take pride in. Such bright students, we still have bright students, but of course the first badge is always very closer to your heart. So yes, and I'm so glad, and I take pleasure of introducing Ms. Ummat Shafkat, and she has co-authored a paper with Ms. Sana Akhtar, a faculty member at Nadra Hassan Law Department. And when Ummat chose this topic of mediation relating to tax disputes, I was like, no, I'm not going to supervise because I can't do it. This is not my domain. This is a very interesting, aspect she has taken. So I really would like to know, Ummat, why you have chosen mediation in relating to tax disputes, and what interests you, and what were your research findings? Is it like something, was it easy to research on such a topic, or what were your limitations? So please, and also introduce yourself, that what you are doing now. We are all interested to know that what our graduated students are doing now.
Assalamu alaikum and good afternoon, everyone. I am Ummatur Rahman Shafkat, a very proud alumni to Nadra Hassan Law Department, and it's a pleasure to be on this forum as well. So currently I'm doing LM in International Law from International Islamic University, Islamabad. So the topic of my research work was achieving justice through mediation with special regards to tax dispute in Pakistan. So mediation, as Atika has already provided you enough background of what mediation is. So I'm going to sum it up again. So mediation is a non-binding resolution involving a neutral third party, which assists the parties to provide with a mutual agreeable solution. So it's a process of self-determination, impartiality, and confidentiality, which has not only recognized by the literature, but has now been also recognized practically. So keeping in mind the Forum of Pakistan, one has to see that this is not something that is relatively new to Pakistan. It has been there in our culture, in our history from the past. One of the examples could be seen in the panchayat system. So we could see that this is something that is not new to Pakistan. And the examples given by Atika, that nowadays, like from a decade back, ADR and mediation has also been incorporated in our major statutes. So the acceptance of mediation in by the society in the ambit of law, where the traditional litigation has failed to dispense justice, it kind of proves that it could be utilized in the fields where effective determination of dispute with the restraint of limited resources are there. So it is very imperative to deal with that kind of challenges. This kind of challenges is first of all imposed in tax dispute. That is not even considered majorly by the normal working of the mediation process as well. Why? Because here we have to keep in consideration that this is not something that is under a confrontation issue. Here there's a one party that is actually a beneficiary, and the other party is an official. So this statute has been made to benefit the public. That is the beneficiary. So for them, we need to have a process that is more quicker, more efficient, and thus provides a forum to a better forum for achieving justice. So taxation, there has been major issues with taxation because there has been growing dispute. Why? Because of the modern tax environment. There has been a modern tax administration environment, and to cope up, we need to provide with a better forum. So the only way to cope up with the prevailing floodgates of litigation, and where the issue of our country's economy is the main issue for that purpose, we need to have this mediation as a forum. And this is what the ultimate solution my research work provides, that mediation is kind of the only solution to the growing demands of our modern taxation environment. So the findings of my research work was there has to be a mediation commission, and for that commission there has to be a proper regulation. And this commission would only deal with the mediation process, and this commission would provide you with a schedule that I have taken into consideration the Australian government way how they deal with the tax dispute. So what they have done, they had provided you with a schedule on their website. This provides you with all kind of tax that could be easily taken into consideration and could be easily determined by the mediation. So a normal taxpayer like me or anyone else, they can easily look upon that website, get to know that is the tax dispute they are having issues with could easily be resolved without getting involved with the tax practitioners. Because here we do acknowledge that tax practitioners are expensive. Though it is kind of part of our field, but we need to help our public at large as well. So for that purpose, we need to prepare a proper schedule, a proper commission, a proper regulation. And to this, to make it a more flexible, we need to have training sessions to tell them what basically tax disputes are, because the system is very complicated. Even for me, though I'm not that much of a practicing lawyer, but I'm very familiar with the returning of tax, the refunding, the waiver, all of this stuff. But still, I do find the system to be very complicated for myself. So think about the fact that this statute has made the public at large a beneficiary, and for them, how complicated the system would be. So we need to have these sessions for the member as well and the for public large as well. Another recommendation, another findings was very, to me, that was a very cool finding, because I looked into consideration the different working of mediation by different countries. And what they did was they provided some tips and tricks. And what were they? They reduced 20% of penalty over tax if the parties go through mediation. Similarly, they kind of curtailed the fee that has to be imposed in litigation, but they won't be imposed when the issue would be taken by mediation. So this is how they have kind of curtailed their litigation floodgates, and they have also taken mediation as a way better forum. So in the end, I would say that this mediation process should be in line with our national and international guidelines. So this is more like a very less complicated findings of my research work. If you want to have a more complicated, you want to look into it, you can look into my article that is available on the net as well, and in our review, in other law review book as well.
Thank you so much, Umar. Yes, it was really insightful. And when you shared the example of the other countries, yes, it is something which we really want to speak about. So, people here can, have those as leading or the role frameworks. Probably Ms. Sana wants to add something.
Assalamu alaikum everyone. I'm Sana Akhtar, lecturer at Nadra Hussain Law Department. As my co-author explained very well, I want to add a few things in it. As we know that mediation is basically an alternative dispute resolution strategy. And the primary objective of mediation is basically to improve the trust relationship between the tax administrative authorities and the concerned taxpayer by providing them informal ways to settle their disputes. However, there are some limitations that exist in Pakistan, but if we can see the international aspects, the trend of mediation in tax dispute is also growing at international level. If particular talk about the America, there is also a separate system and their internal revenue system is working on it, and practically in UK the facilitative mediation has been favored. So these are the good role models or example we can follow that. But the problem in Pakistan is that we lack of the precedent in taxation field. I think this is one of the significant reasons which basically causing uncertainty about what mediation would involve or entail. But however, it doesn't mean that it should not incorporate in our financial statute. Beyond this criticism, I think this process is very compatible with the Pakistan administrative system. So I think for the reason that Pakistan from the years has been well familiar with this process through different mediums, still there is that need to research or evaluate the institutional capacity of the system to support such international practices regarding mediation in tax dispute in Pakistan. Thank you.
Thank you so much, Ms. Sana. Yes, you're very right. There are so many things which we really need to work on, and mediation is not only, the next topic is about that. Normally, when we hear about mediation, we keep it associated to the family disputes. But going for the tax and for other fields, we always go for the arbitration, or the first thing comes to our mind is arbitration or litigation. So it is really important that there has to be an administration and institution built which support this idea, and people come to this dispute resolution with confidence. Our next contributor is Ms. Ghazal. Ghazal is a student at Nadra Hassan Law Department. Ghazal has co-authored a paper with Mima Khan. Though their paper was not included in the journal because of certain limitations, there were limitations particularly, but their contribution was really insightful, and it was such a good topic that I really want Ghazal to talk about it, that why did you choose that topic, and why, and what were your research findings, as I just said that as your mediation was related to family issues, so how what research findings were there? Was it easier as compared to if you could have chosen mediation in another field, or what? So we really would like to listen what Ghazal has to say.
Yeah, thank you very much, ma'am, for giving me the floor, and good afternoon, everybody. I am really delighted to be here and presenting the paper that I co-authored with Tamima on mediation, specifically for family cases. Particularly why we chose this topic is because when we talk about mediation or ADR in general, we are often inclined towards a very commercial approach of it. And somehow we forget that it is very important in family cases as well, because I think in family cases, particularly of separation or child custody, there are a lot of sensitive and emotional elements which are connected to it. And whereas in formal litigation, the child has to pay to the court, and the family has to go to the courts, and they have to argue out the cases. So I think it gets really, their personal issues gets really out there, and somehow it also is very detrimental to the welfare of the children. Whereas in mediation, where both of the parties meet in the middle way and find a middle way to solve their issues, is a very civil and is a very, I think, healthy way of resolving a dispute. So our research is basically based on analyzing the role of mediation in family cases. It also put emphasis on the positive impact of mediation and how mediation can be used as a tool for expedient justice. The research also comparatively analyzes the concept of mediation practices in different countries like India, China, and UK in terms of family law. We chose these three countries because of India, because of the cultural similarities, UK because of the similarities in law, and China because they have a somewhat developed mediation process for family cases. So we wanted a comparative analysis of these three countries. It also highlights the challenges that a developing country like Pakistan faces to put mediation into practice. Lastly, it also sheds light on its effect on marginalized groups, especially women in Pakistan, who are quite hesitant to go to the court and argue their case. The interest of mediation has been recognized as an effective and expedient mode of justice. Its advantages surpass the one of the normal litigating process. And the positive effects that it has on the marginalized groups, especially in developing countries like ours, is also something that I find compelling. Lastly, I believe that it would also be helpful for the judicial system of Pakistan, considering the countless cases already pending there. About the limitation, there have been quite a few limitations with respect to the resources and the scholarly work on particularly this topic in South Asian countries, but none of them were catering to resolving family cases, although we got a lot of papers on mediation as a whole topic. This lack of previous research on the topic also puts COVID-19 contributing to limiting us from carrying out any field research. Amidst of all of these confusing and trying times, when the whole country went into complete shutdown, we also had to face a lot of time constraints as well. And meeting our deadlines were almost a challenge for us because we couldn't go and carry out the field work that we desired to do. We wanted to interview a lot of lawyers. We wanted to interview a lot of people who have been working in mediation and get their point of view on the role of mediation in family cases. And this, coupled with the fact that we had restricted access to data, amounted to the most of the limitation we faced in our research. And I think mediation in family cases, which I found through my research, if it is practiced really thoroughly and if it's practiced in a very streamlined manner, it can prove very beneficial for both the parties. So thank you very much. I think that's all from my side.
Yes, thank you. Thank you very much. Just one question, Hazal, as in why you chose this mediation in family matters? As in, was there a particular reason for that, or do you think that it's less explored, or you can add something to the research?
Yeah, I think it's definitely very much less explored. And one of the main driving force behind this topic was when two parties go out in the court and they have to litigate their case. Because I think family cases have very sensitive and very personal element to it. And it's really hard, especially for a woman in this society, to go to the courts and argue their cases or to present their arguments without facing any backlash from their own families or from their in-laws. So whereas mediation, you have to find a middle ground where you meet, and the confidentiality, I think it's remarkable because both of the parties can talk openly without any kind of consequences. So I think, yeah, that was the main driving force behind this topic.
Okay, thank you very much. The next student who has contributed to our journal, I keep opening it and referring to it because it is very close to my heart, and it's actually very beautiful. Marush Tar is with us, and she is currently studying at Nadra Hassan Law Department, and she has co-authored a paper with one of our faculty, Ms. Myra, who due to some personal reasons couldn't be here today. And the topic of their paper is that an insight into settling disputes through ADR mediation arbitration. The first thing I really would like to acknowledge is that I was overwhelmed by the response of the students when we just floored this idea that we are going to have a law journal on the theme of mediation. So it was really overwhelming for me that when students approached us and they showed their interest in writing. I would like to ask Marush that why did you choose mediation, and why you think that mediation is a topic you can research on, and what do you think that what was the research gap you were trying to identify in your paper?
Hello everyone, my name is Marush and I'm a semester 9 student at Nadra Hassan Law Department. As Ms. Asher said, the title of my research paper is An Insight into Settling Disputes Through ADR, with a focus on mediation versus arbitration. So the reason why I chose this topic was that the concept of ADR, the way it has gained such popularity in a very limited period of time, and then also how the young lawyers are so inclined on working on this and actually pursue a career in it, that was the main reason, which actually the main driving force to make me write this article. So for the purposes of the research, I divided the article into two parts. The first part was rather general in nature, as I focused on discussing the role of ADR as supplementing the mainstream litigation, and as to why should people choose ADR rather than litigation for settling their disputes. So I used both international as well as national sources for critically analyzing the merits as well as the demerits attached with ADR. And the research findings, according to my research findings, the benefits and the advantages of ADR are so significant and so extensive that if implemented properly, it has the complete potential to completely revolutionize the judicial system. So in the second part, then I focused, I narrowed down my research, and I focused on just two forms of ADR, the arbitration and mediation. So one thing that I have to say here is that the reason why I chose to compare mediation with arbitration was to basically help the disputants to actually realize which technique is more suitable for their dispute, and to produce a deduction as to which technique will work better for them. But the research findings showed that there is no outright answer to this question, as there are numerous factors involved which actually determine the kind or the form of ADR you should employ. So this is what my article was all about. One limitation that I kept on noticing was that when I was doing the research, the material which was available was mostly of the theoretical kind. Like I did realize that the material, the sources, there was a scarcity of sources when it comes to ADR on a practical level. And I think this could be improved if ADR is implemented in its true substance rather than just, incorporating it into the law or the judicial system with no practical implementation. Thank you. Over to you, Ms. Aisha.
Thank you, Marush. Marush, I have a question which I keep on asking everyone, but almost we have kind of a same answer. What were the limitations you actually faced when you were working on it? Was it like not enough literature, or was it not? Or is there enough literature but not accessible to you? What was that?
Yes, like I said, that yes, people are working very hard on, this concept of ADR, but on a practical level, researches that show the practicality of ADR, I think there we do lack the resources and the material. So that's mostly what the limitations were.
Okay. Thank you so much. Thank you. Our next contributor is Ms. Aisha Khan. Ms. Aisha Khan has recently graduated. She is from our second batch of Nadra Hassan Law Department. Do we have you, Aisha, here?
Assalamu alaikum, miss. I'm here.
Walaikum assalam. So Aisha has co-authored a paper with her class fellows, and I would like Aisha to tell us that why you chose this topic, and what were your interests, and what difficulties you had, and what were your research findings.
Okay, sure. Basically, the topic of our article, the basic information and research, we basically focused on what alternative dispute resolution in general is, and with a more focused approach on mediation laws. And I personally believe that in Pakistan specifically, we're dealing with 1.7 million cases, and the Pakistani courts have exceeded their capacity. Therefore, we need to have an alternative method in place to actually make sure that the cases are resolved. And in furtherance to the above, the cases, they actually span decades, and sometimes even they outlive the litigants' lives. So therefore, it's important that we move from the conventional process of courts to a more resource intensive and a less time consuming process. Therefore, we actually focused on mediation laws, and the basic findings of our research were mainly targeted on, as discussed by the earlier speakers, that we basically focused on what exactly is the scope of mediation in Pakistan specifically, because it's a very growing, extensive field. And I personally was of the opinion that we should actually develop mediation and alternative dispute resolution methods in Pakistan, so as to ensure that cases are disposed of timely, and at the same time, it should be very cost effective. In furtherance to the above, even with regards to mediation in Pakistan, so far that we've seen while we were conducting the research, we actually saw that it has been pretty successful in Pakistan, primarily when you take into account commercial disputes. So as the earlier speakers have focused more on taxation, they focused on family matters, we were more of the opinion how in general mediation can actually improve the basic judicial process of Pakistan, and how cases can be disposed of timely. The basic research of our, we basically focused on a couple of things, which included the basic process of mediation, the process of confidentiality, what are the basic aspects of mediation, how it can be improved further. Then there were obviously a certain number of limitations that were brought into account as well, which actually includes a lack of trained lawyers and mediators in place, because a lot of people aren't very aware of the basic mediation process. Therefore, we do not have trained mediators and trainers in place. And we actually focused on providing them with training, and in our research we put forward certain techniques and education, and we put forward certain education techniques which can actually aid in improving the mediators and their training. And then there's a lack of infrastructure primarily in Pakistan. However, with more awareness, this lack of infrastructure too is taking a step back. In furtherance to this, we also need to take into account the fact that we have inadequate funds with regards to mediation. Mediation is, although a less time consuming process, but at the same time there's certain costs involved, and I personally feel in our research we focused more on how this aspect can be handled as well. Then we have the mediation process in itself. I think all of the problems primarily in our research too, and my co-authors when they were researching, one of the major aspects of mediation and the lack of applicability of mediation in Pakistan is the process itself, because a lot of people don't really understand what the process is. A lot of people aren't aware of alternative methods of dispute resolution, because we've been coming from a very prolonged system of jirga systems, and we've got panchayats, but we never really focused on having a mediator, although these systems primarily focus on having one mediator in between who would solve the disputes. So how about we actually focus more on having an alternative method of dispute, which is mediation in general. So I think that was mainly what the research focused on, and that's about it. Thank you, Miss.
Thank you so much. Very well articulated. And yes, one thing which we have pointed out is inadequate funds. With reference to mediation, yes, that's one of the reasons that mediation probably is not being taken seriously or is not being flourishing, the way it should be. So, but as Pakistan is still struggling with a lot of things and at various fronts. So maybe mediation is not a priority right now, but it should be priority because it is cost effective, it is time saving. So it has so many benefits as compared to the, your adversarial system. So thank you so much, all of the students who have contributed into the journal and who have spared their time on Sunday to discuss their research findings and their interest in research on mediation. Thank you very much. We have our next speaker is another contributor to our law journal, Ms. Mahnur Kazmi. Professor Mahnur Kazmi is a third-generation lawyer and a committed academic. She has been on the visiting faculty of leading Pakistani law schools for the last 2 decades. And yes, she is visiting faculty at Nadra Hassan Law Department. I'm going to mention it, I really wanted to mention it specifically. And Professor Kazmi did her LLB from Punjab University and holds an LLM degree from the University of Virginia, USA. During this time, she collaborated with some of the leading scholars in biomedical ethics and with Professor John Norton Moore, Director of Center of National Security Law and Oceans Law and Policy. She specializes in civil, constitutional, intellectual, and commercial law. And it's always a pleasure speaking to Ms. Mahnur. And, thank you so much for gracing us with your presence. And thank you so much for your contribution to our research journal. Over to you, Mahnur.
Thank you so much, Aisha. Thank you so much, Nadra Hassan Law Department, Asia Foundation, for having me over and giving me opportunity to contribute in your publication. It was a wonderful experience. So the reason I got inclined on writing on this
We just lost you, Mahnur. We are unable to hear. I think there is some connectivity issue, the virtual world. Ms. Sana, can you please check with Ms. Mahnur?
Okay, give me a second, please.
Yeah. We'll just wait for a minute for probably Ms. Mahnur sorting her. I think meanwhile, as Ms. Manur sorts her technical issue, probably there is some internet connectivity issue. We can move towards our next speaker because we have limited time. Um, I think yes, Ms. Manur is still not here. Ms. Sana, do we have Ms. Manur with us?
She's joining.
Okay, she's joining. So I think we can just wait a minute so she can, continue. So now we can move.
I'm so sorry about that.
No problem. It's the
I'll,
world we are living in.
I'll just wait. No. I'm so sorry about that. Last thing I was expecting. I'll just wait for. I think Mr. Zishan is speaking.
No. Well, we didn't actually invite Mr. Zishan yet. We were about to.
Okay, so I kind of now, like, since you lost a little bit of time as well, so I just quickly jump to the point why it intrigued me. Though my training at University of Virginia has been as a student of comparative law and religion and company law and the comparative constitutional law, but ADR has always been very mesmerizing in the respect that if you look at it, something like, you have a whole structure of civil litigation. And as a civil lawyer, I know that, it's like the only, where there's a right, there's a remedy and all that you've studied all your life. And all of a sudden there's but a long procedure to be followed. A civil litigation, as soon as you speak of a civil litigation, it's too harassing, as in term of time, that is going to be an unending procedure. So there's something which is more fascinating, which is going to give you justice, but in a more kind of quicker way, as one can be promised, and through different ways, mediation, through, as I was about to say, that arbitration has been there, and we have been familiar with it since 1940, and we got very good arbitrators over here, very skillful. But since 2000, there has been in the whole situation, we've got more provisions now available to us on the statute books, which I have kind of, given a monopoly of those statutes as well in my paper, which now have ways to go and get the matter settled out of court as well. We've got them on criminal side, we've got them on civil side, in commercial, in family, we always had to a limited kind of, aspect and sense of it. But now we have like a more developed thing. So I thought that we needed to research about it and get educated as, legal researchers and legal faculty members and practitioners on it, because a lot of people do not have any access to information about it and knowledge about it, and how to, as to how, what we've got for display for them for out of court settlement. And that's why I wanted to collect the entire information as I could. I even try to touch, the historical perspectives. I tried to stay away from the comparative religion, the germs of that thing, but I could not help because I thought it would be an interesting thing there. And then how it works. That's how I got intrigued to, writing on this thing. Whereas Aisha, my limitations are concerned, which has been a question through, I was saying that, what limitations have as a researcher, as a writer, I come across. Though we have a lot of, records and stuff available in the public domain, yet if you try to look at particularly for something on ADR, it's very difficult reaching out for such stuff. maybe for a person like me who's like been a legal practitioner, or who has been a researcher, a keen researcher, or a law teacher as well. For me, it was slightly less tougher, because I had an access. But I just, what I realized was, for a normal person who wants to research on this point, for him, he has to have a huge, access to the databases, the records, going, a team of people who can really reach out as practicing lawyers, or a keen researchers who just want to research for themselves and go. So the empirical data, there was like, as they say, a little bit of dearth of it. I couldn't find it that much, or at least I just, kind of got it for my paper, for everybody, for the readers to read, and if it to, make it helpful for them. But it was a problem. Yes, it was a problem looking for data. Secondly, another problem, limitation that I kind of saw while I was looking at it, that compared to, along with the quantitative, a little bit of qualitative, problem as well, because when you're looking at a material, you like to see it working, how it works. If I'm looking at a paper, or I'm looking at a judgment, I'm trying to see, or a record, and I'm trying to see how this thing works. And is it really all these amendments since like 2000, which have been one by one incorporated in the different statutes in Pakistan, are they really working the way they were intended to put, or intended to work, or whatever the intention was of the people who made them a part of the statutes? So there is a little bit of a problem over there as well, because because the way it should be, an order should be speaking, we always, it's like the same again, old thing, the speaking way of a judgment, and the reader should be able to, or a researcher, as in our case, should be able to find out as much as he wants to find out from that thing. But if you look at the records, as I would give you an example of the family matter, that comes like, because that's like, in that domain we have a lot of mediation, at least on the papers, pre trial reconciliation, and post trial reconciliation, we got that. So if you look at it, if I look at a record, which is an order of the court, which is like which carries all the working, how it works, the order sheet, it's just, if a pre-trial reconciliation has place, all what would be written would be like in like a 4 lines or 12 words, saying that the reconciliation has been taken place, parties have met, and they cannot live together, full stop. That is it, inverted commas closed, and that's all we have it over there. How, what ways, to what extent you're deciding about rights of a family, going on to rights of children. And that's all what a researcher will be able to find out, or a person, or public, or anybody would be able to find. So that was also one of the things that I think that when we have orders, or we have like material, they should be more detailed, unraveling the steps as to how and to what extent they've been taken. So I think that is also one of the things which was kind of hustling for me to look for, and for people as well who are researching over it. So, and any other questions, and if anybody wants to find out, my email is there, and I'm like always welcome to answer those, any videos.
Thank you so much, Ms. Mahnoor. Yes, I think you have rightly, stated the limitations. Of course, if the resources are there, you are unable to reach out, and if you just find them, they are incomplete, and initially you have to struggle a lot to look for the resources. I think that's the problem we face. Whenever we are researching. So that's why the research culture is not really flourishing, I would say, because the quality research, as it was mentioned earlier, that is actually missing from legal field, particularly, from the local authors, I would say. Thank you so much for your time, and thank you so much for your input. And yes, I can vouch for this. This Professor Manur is always available for your help and assistance.
Thank you so
Thank you so
much.
much. Our next speaker is Mr. Mohammad Zishan Zafar. And I take pleasure in introducing him because I'm actually meeting him for the first time. But he has such an impressive profile. He is an alumni of University of Pennsylvania and is a dual licensed attorney in the state of New York as well as in Pakistan. At Pennsylvania, he was also serving as the associate and symposium editor for the University of Pennsylvania Asia Law Review and also part of the prestigious Penn Law Mediation Clinic. Mr. Zishan has represented at various national and international forums regarding human rights and sustainable development. Thank you so much, Mr. Zishan, for joining us today. Please do tell us, because when I was going through your profile, I actually saw that you were a symposium editor. Also, you were part of the mediation clinic. So please do comment that what do you think that we in Pakistan lacks in research relating to mediation, and what, as a lawyer, you think about the importance of research relating to mediation. Over to you, Mr. Zishan.
Thank you so much, Aisha, for having me here. I listened to Manhu Kazmi, who was also a US trained Pakistani attorney. Let me begin with one example which my professor gave when I was at Penn Mediation Clinic. He gave me an example of a pyramid. And he started with okay, in America, in US, for example, there are 2,000 disputes. And only out of these 2,000, only 1,200 would end up in legal claims. And when they end up in legal claims, they would have a lawyer attached to it. For example, if you have a legal claim, you would have a US attorney attached to it. And then after a US attorney is attached to that legal claim, only out of those 1,200 legal claims, only 80 or 90 would actually go up in trial and they would be settled in court. And out of those 1,200, all of them except those 80, they will end up in out of court settlement. They will end up in mediation. And that is why a US attorney is respected all over in US. Let's see an example of Pakistan. It's totally opposite. It's a total opposite pyramid. Let's see, for example, let's start with the first different pyramid. You have 5 disputes. Let's take a divorce matter, for example, a matrimonial dispute of a husband and a wife. And then of those 5 disputes, you attach a Pakistani lawyer to it. And these 5 disputes will actually multiply in 500 disputes. A Pakistani attorney will recommend his client, okay, let's file a claim against the brother, against the father, and against everybody in the family. And that is why in Pakistan, you see what is the impression and respect of lawyer. And I think these all things matter. Having worked in US, I think being a lawyer, you have to help your client seeking a resolution of the dispute. But in Pakistan, lawyers are not doing that. You see how these lawyers are reacting to the latest amendments. And out of these amendments, there's also a newly added Order 9B, which mandates the court to send these cases out of court in a mediation center, which will be set up by Lahore High Court. And then the court will be part of the mediation process as well. But you see, I see lawyers going on strike because of these CPC amendments. And you know what? The basic reason of these strikes is, okay, these amendments will somehow will be an obstacle to the legitimate earnings of lawyer. I don't understand how it is possible. So I have listened to Manu Kazmi. I also listened to some of the speakers. I think it is a wonderful thing what you are doing, and mediation specifically is something which is going to be very important in Pakistan in near future. Because Aisha, believe me, in Pakistan, clients and the litigants, they are not being heard by judiciary. They are not being heard by judges. When I say that, if you have a dispute, let it be a house dispute, a simple dispute, for example, you want to be heard, and the judges cannot do that. They have plethora of cases. Single civil judge has at least 200 cases in a single day. It is humanly not possible to listen and to every grievance of every client or every litigant. So I think mediation has a role to play. I can go further about mediation. If you have any question regarding this, what I just mentioned, I'll go around that.
No, I just want to ask one thing. You're very right that, in Pakistan, 5 disputes will end up in 500 because we've been trained like that. We've been trained for litigation, not for mediation. Do you think that this growing research culture on mediation, relating to mediation, is going, will make lawyers to accept mediation, because that will be something, everybody will be talking about, everybody will be discussing. So they might end up in adopting this trend, or will we still be having or facing difficulty as we are right now relating to amendments?
Mm-hmm. Yes, that's a very good question. And I think the answer would be there are two hierarchies of lawyers in Pakistan. One of the hierarchy, they tend to focus on their earnings, and the other lawyer is, like, I call a true professional who wants to help out his or her client. So with this second kind of hierarchy, I think these research, these would definitely help sensitizing them to the mediation and importance of alternate dispute resolution. Going about this, recently I have a US client and I'm working on his Pakistani case. And he was like, why don't you contact the lawyer of other side? Why don't you settle this dispute? And to his amazement, this is not the process in Pakistan. We do not have a pre-trial reconciliation opportunity where we would sit with the other lawyer. Here, the lawyer also becomes adversary of another lawyer. This should not happen. In the legal industry, we are supposed to, we say, okay, legal fraternity, but it's not a fraternity anymore. If you have a client and your client and the other lawyer, you will treat him as like an adversary. So this is also a bad thing. And I think research would definitely help lawyers being mediators, because in the future, lawyers, they have to play the role of mediators. And as mediators, it is a very different game altogether. You are not going to be the judge of your client. You're not going to evaluate his case or her case, and you're going to make a solution. You are going to cut out a deal which will work for both of them. It is not a zero-sum game, which is litigation. It is a win-win situation. And you are not going to create more problems. For example, if you go to court, and even if you have a judgment in your favor, I'm sure that you will get your one legal problem fixed, but you will create another emotional problem for you and the other party, which will never be fixed. So I think mediation offers some kind of dispute resolution where the entire problem can be solved.
Yes. I think you're very right, and I think we need lawyers who think like this, that mediation is going to solve the problem rather than creating problems for the legal fraternity. And I think more acceptance is needed. Thank you so much, Mr. Zishan, for such an insightful talk. And also, I would really like you to stay and listen to our keynote speaker, Mr. Jawad Sarwana, later on, because I think your a lot of concerns will be sorted out when he will be speaking about his experience as mediator. Thank you so much for your presence and taking time out. As we are short of time, so I'm going to invite our the next speaker, Ms. Uzma Zahoor. Ms. Uzma Zahoor is a civil judge cum judicial magistrate and presently working as research officer at Lahore High Court. She did her LLM from Superior University by securing first position. She holds the role of honors from Lahore College for Women University. Ms. Uzma has represented women judges on many national and international forums. Recently, she has represented women judges in 14th Biennial International Conference, Building Bridges Between Women Judges of the World in Argentina in 2018. So thank you so much, Ms. Uzma, for taking time out. Do we have Ms. Uzma here? Ms. Uzma, can you hear me? Ms. Sana, can you please check? Because she was here a while ago.
She is in meeting.
Probably, Ms. Uzma, you need to unmute your mic.
Hello.
Ji, Assalamu alaikum.
Walaikum assalam. Good afternoon to everyone.
Good afternoon. Thank you so much, Ms. Uzma, for taking some time out. And we really want to hear from the judiciary point of view that how you, judiciary is taking mediation and how and what work you people are doing at the research center at Lahore High Court. Please brief us about this.
All right. First of all, I'm really gratified and auspicious to be part of this webinar session. And it is really an honor for me to contribute my voice on this very imperative topic, as it is need of time to be reformative in all respects, particularly with matter of research, technology, globalization in respect of dispensation of justice. As far as dispensation of justice through alternate dispute resolution is concerned and the role of judiciary in this regard is concerned, let me clear you first of all that it is not a new phenomena in legal terminology. It is not also an alien term, and it is not something nor revolutionary concept in the judicial system itself. I must tell you that it existed. It existed in form of arbitration, mediation, conciliation, summary trials, and early neutral evaluation. However, I do admit that it's been least focused, rather ignored, overlooked, and neglected. But still, I'll say that it existed. And I'm really glad that we are resorting towards ADR and we are striving to give its due place in our legal system. As far as court's role is concerned, I'll start with that it is said that without courts, law remains dead letters, as these are the courts through which law is enforced, expounded, and operated. So the courts give life to the dead letters of the law, which gives life to a civilized society. And I'll say that supremacy of law is the only tool for the disciplined and orderly growth of a nation. Even socioeconomic and political climates have nexus with the system of justice. Dispensation of justice is direct phenomena of prosperity, and the miracle of prosperity are straight away dependent upon the law enforcement. I'll quote an American leader, Martin Luther, who said that law and order exist for the purpose of establishing justice. And when they fail in this purpose, they become the dangerously structured dams that block the flow of the social progress. Therefore, I must say that the courts have really vital role to won the laurels for safeguarding the basic rights of the basic fundamental rights of the citizens and the spirit of constitution, enchanting rule of law, exhibiting principle of equity, and showering peace and harmony. So the recent trend of adopting alternate dispute resolution in administration of justice is more substantial. In a judgment, Honorable Islamabad High Court has observed that expeditious and inexpensive dispute resolution is the lifeblood for vibrant economy and inevitable for economic growth and progress. You can also note down the citation for the reference as it is 2015 MLD 746. I'll add that apart from being expeditious and inexpensive, this system also creates harmony and respect to mutual commitments. It lets the parties in a cordial relationship after amicable settlement, as it is almost like repeating that they also save the parties from procedural and legal technicalities and producing formal evidences as required in normal litigation. Through this more complex and series of litigations can be curtailed because of less chances of appeals and revisions. As you know that in case of decrees which are not the result of the mediation, those are not the result of settlement, definitely the other party approach the appellate court or revisional court against that order. So that is why I'm saying that through mediation, the complex series of litigation can be curtailed because of less chances of appeals and revisions. I will add that I earlier said that in judicial system, the alternate dispute resolution existed, and I am a research officer, so all my words should be based on the research, and I should quote those very references which will support my all the words and all the sayings. I'll start from the Constitution, that Article 37D of the Constitution of Pakistan, emphasis to ensure inexpensive and expeditious justice. Alternate dispute resolution is also the key factor of the key feature of the National Judicial Policy. Recent developments in shape of Alternate Dispute Resolution Act 2019 are also very much important, which contains some sort of confidentiality, and it also prescribes the legal procedure in this regard, which is really very strengthening towards the mediation system in Pakistan. And as far as other legal backing of ADR in Pakistan are concerned, then the Arbitration Act is its Arbitration Act 1940 is its glaring example. Further to it, the Family Courts Act, as it is almost said by Ms. Mahnoor, that pre-trial and post-trial reconciliation proceedings existed in that very act. Similarly, the Muslim Family Laws Ordinance 1961 also provide for arbitration counsel to exercise the powers in this regard. Similarly, Section 102 to 104 of the Local Government Ordinance 2001 provides the Musalhat Anjuman offices to achieve the amicable settlement of disputes amongst the people in the union through mediation, conciliation, and arbitration. I'll refer other sections such as Section 195C of Customs Act 1969, similarly Section 134A of Income Tax Ordinance, Section 38 of Federal Excise Act 2005, Section 47A of Sales Tax Act 1990, Section 345 of CRPC, and Section 14 to 9 of Small Claims and Minor Offences Courts Ordinance 2002. And least but not the last, Section 25 of National Accountability Ordinance 1999, which also provides for the plea bargains. And as far as I have to tell about the mediation in the judicial system of Pakistan, I will also tell you that the courts are now more activated to encourage move of alternate dispute resolution and honor the commitments of the parties. In its various judgments, the Supreme Court has also settled several principles. For instance, in PLD 2016, Supreme Court 19, the Honorable August Supreme Court held that agreement between the parties had the status of a statute. So this is very important sort of judgment of the Supreme Court, which is emphasizing and focusing on the importance of the agreement between the parties regarding the mediation, that any agreement has got the status of a statute, and when it got a status of a statute, so it is also mentioned that unless it was shown that any term of the agreement was violative of the law, it could not be rescinded by the parties. So it is also binding the parties in this regard. Similarly, in another judgment of the August Supreme Court 2018 SCMR 662, the court have discussed different grounds for setting aside arbitration. There are also other judgments which I'll definitely be available as I'm related to the research matter, and I am the research representative of the Lahore High Court, Lahore. So I'll all time be available to all of you to provide all the assistance in this regard in future, and I'll be available to answer any questions in this regard right now. Now I'll discuss something about international arbitration in Pakistan. As you may know that Pakistan is adventure of New York Convention 1958, and prior to it, Pakistan has also ratified Geneva Protocol on Arbitration Clauses of 1923 and Geneva Convention on the Execution of Foreign Arbitral Awards of 1927. The purpose was to effect international arbitration and give effect to foreign awards. Pakistan is now also member of different international platforms of arbitration, such as Multilateral Investment Guarantee Agency, International Center for Settlement of Investment Disputes, United Nations Commission on International Trade Law, International Chamber of Commerce, International Court of Arbitration, International Council for Commercial Arbitration, Permanent Court of Arbitration, and American Arbitration Association. I'll also tell you that after ratifying the New York Convention, Pakistan first brought the recognition of Enforcement Arbitration Agreement and Foreign Arbitral Awards Ordinance 2005, which was eventually promulgated as Recognition of Enforcement Arbitration Agreement and Foreign Arbitral Award Act 2011. It was further amended by the Act 2019. Aisha, I'll say that earlier there was.
Mrs. Nam, I have a question.
Yeah.
As
Yeah.
you're quoting that there are so many laws which are in place for mediation, for arbitration. Do you think that as a government is doing a law, judiciary is doing their part of the work? But do you think that lawyers are accepting this transition from adversarial litigation towards mediation or towards ADR? As a judge,
Well,
what do you take?
Right. Well, I'll answer that. I'll not blame all the lawyers, but I think I have heard Mr. Muhammad Zafar. I think you are also hearing me, but he has directly said that the judges do not listen the litigants. I'll humbly disagree with you, Learned Counsel, because I think that judges do hear you. They gave you the opportunity, but I'm really sorry to point you out. It's not we are really sitting on the same stay at the same stake. So we must agree that there are some faults on the parts of the lawyers, as well as your strikes are also creating hurdles, and unnecessary adjournments are also creating hurdles. And as you have also mentioned,
and probably the working environment maybe, because all judges are not the same. Likewise, all lawyers are not the same.
All lawyers are not. That's why I said that I'm not.
I really would like you to just give a concluding remark, because we are really short of time, and one of our worthy speaker is also waiting to share his view. So I really would like to conclude your talk.
Well, I'll say that practical steps what the judiciary has taken, you have observed that in recent past, ADR centers are established and the matters are being referred to the ADR centers. And this is really showing good results in terms of mediation. I do appreciate our lawyers community as well, because they have also really contributed in this regard. I also say congratulate to the education system as well, who are actually raising the awareness campaigns in this all record. But still, I think that we are what the lawyers are doing, what we are doing, what you are doing. Still, there is need of the awareness among the public. Because it is ultimately the public who we are trying to benefit them. So awareness through media, awareness through lawyers, awareness through educational institution, and awareness through court, through its seminars, through its research, through its publications. That is really important. I, being the part of the research team, is really trying hard to focus on the mediation and conciliation. And I congratulate you and the people like you who are really focusing on this issue. Thank you.
Thank you so much. Thank you so much to give us such a wonderful insight. And I'm so glad that this webinar, we have diversity. We have, a person from Judiciary Research Center. We have lawyers. We have researchers. We have students.
Yeah.
And the person I'm going to introduce now, actually, I always wanted to hear from him. Our keynote speaker for today and our worthy speaker, the next speaker is Mr. Jawad Sarwana. It is a great, great, great pleasure to have Mr. Sarvana amongst us today. Mr. Sarvana is a practicing Supreme Court advocate, a partner of Pakistani law firm, and a UK accredited commercial and investate mediator. As one of the founding members of Pakistan Mediation Association, he has conducted various workshops and accreditation courses on mediation. Mr. Sarvana has authored various publications on mediation, and he has also judged various ICC international mediation competition. He's a master mediator and a negotiator. I welcome you, sir, and thank you so much for gracing us with your presence. And I could see that Mr. Sarvana is being present in this webinar since the very start and is, constantly commenting in the chat box. And thank you so much, sir. And it's a great honor and pleasure to have you with us. Over to you, sir.
Assalamu alaikum, and thank you, Aisha, for inviting me. It's a pleasure to be here. Assalamu alaikum to all the friends. I hope आप सब खैरियत से होंगे और ख़ास तौर पे COVID-19 के लिहाज से आप सब सेफ हैं, सब के रिश्तेदार खैरियत से हैं और हम सब एक अच्छी जगह पर हैं. और अच्छी जगह से अगर हम शुरू करते हैं तो the fact that I've really had a great time listening to all the great excellent research work that's been put in this in the last 2 hours. I've been mediating in Pakistan now, although my gray hair doesn't reveal it, but I've been practicing mediation since 2006 now, and so it's been a while since I've been here, and it's still, I'm afraid, a very lonely space. But I'm so excited that it's picking up speed. And of course, whenever there's change, there's resistance, because change means that we need to change our old ways, and changing old ways means learning new things, and learning new things means taking time out from what I already know. And so, those are a part of the growing process. And today's presentation that I have on very short notice. So thank you, Aisha, but still, if there may be a lot of gaps in here, but I will try my best to summarize. Because I think what I found here in all the papers is something that really picks up in my session, which is that those missing voices, right? Whose voice are missing? In a research, right, the idea of postmodernism is to introduce that missing voice. And where is that missing voice? Here we are of a college full of women. And, if we look across the wall and we see what's outside, it's much less women. And so as we move forward, I think, one of the things that you should be thinking about as I go through this process in the next, 12 minutes is I will try and identify areas of research that I think are so important, and from a gender perspective, from an age perspective, from race perspective, that are research points that we need to look at and investigate. And why do we need to investigate? Because when we do research and we are conscious of all the things that exist, it is only then that we can really address it. And it's not only that alone. We need to take another step. And the other step is recognizing that there is a certain inequality and then addressing it. And I will come to it when I elaborate and go into the topic, which is research and mediation, looking at gender, age, and race. So why is it that I'm talking about this? Well, one of the reasons why I'm talking about this is because I belong to an organization, and although these are my points, but clearly this is something that's very topical, and I'm just going to add it to the chat box. And you don't have to go now, but you can go on it later. But the organization that I work for, which is the Center of Effective Dispute Resolution in London, and I'm a faculty member of this organization, it's a very important thing that for CEDA, my organization, which goes around the world training mediators and accrediting mediators, that we are diverse and that we are inclusive. Up, theek hai, that's in their context from London, they are diverse and inclusive. but that is no reason for us from a Pakistan perspective to be equally diverse and inclusive. And diversity and inclusive means recognizing that, you know, there is some sort of bias, and we all have it. We're all human beings. As much as we try to be fair, as much as we try to be just to everyone, there are some inherent biases that we have, and then recognizing those biases and dealing with them and addressing with them. So I think I had asked Aisha also, you know, sort of talking about diversity and inclusion, that what is the starting point of diversity and inclusion, right? So the first step of diversity and inclusion is recognizing कि भाई मुझसे भी मैं भी जो है ना क्या कहते हैं biased हो सकता हूँ, right? और कैसे biased हो सकता हूँ? ठीक है, एक मिसाल ले लें कि मैं मर्द हूँ और मैं बाप हूँ, मेरी 2 बेटियां हैं, तो मैं ये कह सकता हूँ कि भाई देखिए मैं तो सेक्सिस्ट हो ही नहीं सकता क्योंकि मैं तो 2 बेटियों का बाप हूँ, तो मैं कैसे भला सेक्सिस्ट हो सकता हूँ, मैं तो हो ही नहीं सकता। तो ये जो एक पर्सपेक्टिव है, ये एक सेक्सिस्ट पर्सपेक्टिव है कि मैं नहीं हो सकता। इसको मुकम्मल करने के लिए मुझे अपने आप को ये याद दहानी करानी पड़ती है कि नहीं, मैं सेक्सिस्ट नहीं, मैं एंटी सेक्सिस्ट हूँ। उसका मतलब ये है कि मैं हर वक्त अपने दिमाग में ये सामने रखूं कि जब मैं किसी सिचुएशन में आता हूं, मैं सिर्फ मर्द की हैसियत से उस कॉन्वर्सेशन में दाखिल नहीं होता, बल्कि मर्द के अलावा जो उसके स्टीरियोटाइप्स हैं उसको भी सामने रख के बात कर रहा हूँ। जो दूसरा आदमी सामने है वो मुझे कैसे परसीव कर रहा है। अब ये बात थोड़ी सी थ्योरेटिकल लगती है, मगर अगर मैं थोड़ा सा रिवर्स गियर में जाऊं और अपने आप को मीडिएटर की सीट में डाल दूं और मेरे सामने 2 फरीकैन मौजूद हों, तो एक तरफ एक स्मॉल मीडियम एंटरप्राइज की औरत हो जो अपनी वुमेन बिजनेस रन कर रही हो और सामने एक मल्टीनेशनल कॉर्पोरेशन का फाइनेंस डिवीजन का एक हजरत हो, तो दोज डायनामिक्स डू मैटर, right? So I, as a mediator who needs to restore communication, must be cognizant that there is a power imbalance in the room between the two, and that I, as a facilitator, must recognize it. Simply saying that I am fair and I am a father of 2 daughters does not make me does not help the process. I have to say that I am a father of 2 daughters, but equally I need to engage the system and restore communication. So this whole idea of gender, age, and race, which we need to research on, begins with this idea of identifying who you are and where you are in your bias. And so I had asked Aisha to share what the Harvard University has put out as the Harvard Implicit Test. And anybody can take the test, and it has different categories. I took my category of test, and you can choose your category of test from the Harvard Implicit Test. So अब जो मैं कुछ बातें करूंगा, that will be based on the presumption कि आप सब तुलबा ने, आप सब जो लोग सुन रहे हैं, उन्होंने एक दफा हार्वर्ड इम्प्लिसिट टेस्ट किया होगा, और नहीं किया तो इस छोटी सी प्रेजेंटेशन के बात कर लें। उसके बाद जो दूसरी चीज जो मैं बात करने जा रहा हूँ, वो एक साहब हैं who's become quite popular in race relations in America, और उनका नाम है एब्राम एक्स केंडी, और उनकी एक TED talk है which I had also forwarded to Aisha and suggested that everyone should hear it out, and that actually deals with this idea of bias, unconscious bias, right? And so the idea of unconscious bias is that when you say, and he talks about race relations, and he says that when you say you're a racist, that's just a passive way, or you say you're not a racist, that's just a passive way of saying, of doing nothing about it. But what Kendi says is what you should do is you should say you're an anti-racist, because when you say anti-racist, you say that means that you acknowledge कि हम सब जो है ना वो हम में bias है, मगर आप recognize करते हैं कि आप इस bias को दूर कर लेंगे, और आपसे अगर कोई गलती हुई है, कुछ अनकही बात आपने कह दी है, तो आप उसे undo कर देंगे। वो बिल्कुल ऐसी बात हुई कि किसी खातून ने कहा कि भाई देखिए मैं तो सेक्सिस्ट नहीं हूँ, मैं तो औरत हूँ, आई बिलीव इन वुमेन्स राइट, और दूसरी तरफ जाके कह दिया कि भाई देखें अगर आप लॉ प्रैक्टिस करना चाहती है ना बीबी, क्रिमिनल लॉ मत कीजिए क्योंकि वहां मर्द होते हैं और क्रिमिनल लॉ जो है ना औरत का काम नहीं है करना। सो अगर औरत ही ये बात कह रही है तो क्या ये बात रेसिस्ट है? तो इसका सोल्यूशन क्या है? इसका सोल्यूशन ये है कि रिकग्नाइज करना एक जुमले में कि मैं रेसिस्ट नहीं हूं और दूसरी जुमले में कोई ऐसी बात कर देना जो बिल्कुल ही उसके मुआफी हो। मगर अगर आप एंटी रेसिस्ट हैं, एंटी सेक्सिस्ट हैं, आप रिकग्नाइज करते हैं कि भाई मुझसे गलती हो गई, अरे भाई मुझे माफ करना, मुझसे गलती हो गई। क्यों? क्योंकि इंसान अपने आप को बेहतर जब ही कर सकता है जब वो रिकग्नाइज करे कि गलतियां हो सकती हैं, राइट? सो दिस होल आइडिया ऑफ जेंडर, एज एंड रेस. Now let's connect this idea which is built on in order to research gender, age and race, the first step is recognizing. How do you recognize? Well, someone either tells you or you take the Harvard implied test that generally will give you an idea कि from a scale of 0 to 100 आप कितने biased हैं। तो आपको खुद ही अपने बारे में आ जाएगा। It's based on a logarithm, ठीक है, mathematical algorithm है, it may not be 100% correct, but somewhere, you know, it will give you some idea. So the first thing about research in gender, age and race in mediation is recognizing it. So when I look at mediation and excellent work by all the participants here today, you know, talking about the history of mediation. But one thing that really strikes me, and the idea is just simply to identify areas of research. So मेरा मकसद जो है वो यही है कि मैं आइडेंटिफाई कर लूं कि भाई देखें ये भी एक पहलू है. So what's the पहलू that I thought that you know all the students here for next year, or I don't know if this is a quarterly publication, can look at and explore in the history of mediation. So the first thing that struck me as I was being trained in 2006 was the idea कि panchayat, jirga, salis, who was the absent party in that? Women. I mean, I have not seen women participate in a panchayat. I have seen even in my village, in the village jirga of my father-in-law, who is from Sindh, you know, have men participate. I haven't seen my chachi go and conduct a jirga in the interior. I'm sure there's the same case in Punjab as well. So when you're looking at research, look at when people say, "Arey, hamare paas to mediation sare saal chalti rahi hai," well then think about जो process of mediation आपको इस वक्त बताया जा रहा है, how different is it from how jirgas and panchayats are conducted? What is the element of gender? What is the role of gender? And what are the processes that have been introduced in the current form of mediation process that actually try to restore gender inequality? And what is it that is happening on that stage in Pakistan, right? So where is it that we are looking constructively to gender, and where we want to take things in Pakistan when we are looking at the historical roots? And that in itself is very interesting, because why is it so interesting? It's interesting because where Pakistan is in mediation, right? So let's go back a little to the history of mediation. In 2002, the Asian Development Bank introduces a change in the Civil Procedure Code of India, Pakistan, and Bangladesh. In 2002, we have these three laws suddenly change. Why? Because गोरे ने कहा पैसे नहीं दूंगा जब तक तुम जो है ना अपने कॉन्ट्रैक्ट इन्फोर्समेंट को सही नहीं करोगे, और उसने कहा तीनों चलो बदलो अपनी लॉज. तो तीनों ने, इंडिया, पाकिस्तान, बांग्लादेश ने 89A डाला, इंडिया ने 89ABC डाला और बांग्लादेश ने 89ABCD डाल दिया. अब इन्होंने कंस्ट्रक्ट बना दिया मगर कुछ नहीं हुआ, कैपेसिटी बिल्डिंग कुछ नहीं हुई. So 2002, 2003 ये होता है. Then again, you know, what happens is, you know, when you hear about when you hear about loans, right? When you say, "Arey, Pakistan ko IMF se grant mil gayi." So remember, when Pakistan gets the grant, it's also connected with some policy decisions, right? So some of them are money in terms of cash, but a lot of it is money in terms of programs. So what happens is in 2007, the IFC World Bank decides that they're going to train about 250 lawyers in Pakistan between 2006 and 2012, and they're going to bring them up to speed on what is mediation and accredit them as mediator by an international organization called CEDAW, which is my genesis, my birth organization. So now where does gender come in? When IFC is deciding कि उस 200 लोगों में से कौन वो बनेंगे mediators, they are very cognizant कि भाई diversity and inclusion को सामने रखना है. So we get a very controlled formulaic result where people pass, people fail, but over a period of a good 5 years, you get an equal balanced gender of mediators in Pakistan from 2007 to 2012, and that's in Lahore, where there is a civil judge program that's run, and Justice Asim Mansoor also becomes an accredited mediator in that process from CEDAW. He's the first honorable judge who's now in the Supreme Court. He's a CEDAW accredited mediator. He's in that cycle. He gets his accreditation from Egypt, and there are other 80 civil judges who become accredited in Pakistan in 2008, and there are men and women, right? There is a division there, and so we have that. Now let's fast forward. That's 2012. I can't have everything in 15 minutes. So we fast forward, and so now you are at a point where you're saying we're going to have mediation clinics, we're going to have mediators, and the question now arises is, how many of these mediators will be women? How many of these mediators will be, from a certain, will be Siraiki? How many of these mediators will be from a certain Multani, Faisalabadi, from an ethnic perspective, because that's a different race perspective. After the 18th Amendment, Punjab, Sindh, KPK, Balochistan are all going to have a very different perspective on their journey on ADR, because they're all changing laws and influencing mediation very differently. What's happening in Sindh is very different from what's happening in Punjab. So your issues in Punjab are going to be very different. And that's a question for all you young researchers. कि भाई ये कंपैरेटिव एनालिसिस करें कि जो सिंध में वो कर रहे हैं वो कितना कामयाब हुआ है और जो पंजाब में करने जा रहे हैं वो कितना कामयाब हुआ है. Explore what has happened in the past in the history of ADR in Pakistan so far. This question of lawyers resistance, what has been addressed now that's new, what has the judiciary learned from its experience from handling this situation. We had a horrible situation in Sindh in 2012. The ADR center was burned to the ground by the lawyers, right? So that's a very violent response. You think that the stereotype is, right, Punjab gets very violent. Guess what? The Karachi lawyers burnt it down. So the thing is that that's a history, and it has both race and gender in it. Achha. So that becomes how is mediation developing, and how gender plays a role as a research perspective. So when and I'll go into examples, is that when Atika talks about statistics in Chakwal, right? And so when Atika was saying कि भाई चकवाल में 577 cases हुए, 217 decide हो गए, तो मेरे ज़हन में था अच्छा, okay, so how many of these cases were involved women? How many mediators were women in that place? What was the role of women lawyers there? How was gender making a difference in this, right? Because remember, one of the stereotypes that we have for gender, especially women, is that they're great in relationships, right? And restoring relationships. And so that becomes a research point to see if that stereotype matches or not. That's an analytical research in mediation, right? And then where else? In Ghazal's topic, I heard family mediation, and so I'm hearing, okay, so if these are family mediations, how are we looking at gender, what is the decision criteria? How many times has the child had custody in the mother's favor, even though the father had moved on with the second marriage? What's the statistical analysis? ये statistical analysis क्या दिखा रहे हैं, क्या trend है, is how are these cases being decided? Because now, where we were 20 years ago, khula ke cases to chutki baja ke decide ho jate hain. It is now an accepted position in law that a woman has the same rights to declare divorce, even though she hasn't signed section 17 of the Nikah and she can still enforce khula in record time. In Karachi, an average khula case will only last a month. Previously, it used to be, 3 years. So khula has accelerated. That may be an exception that I'm aware of, where it lasted only a month. But as I see Aisha going back in her seat, but the thing is that it's still much faster than it was. So really now what you're looking at is at custody. So from Ghazal, and for those who are listening for next year or the next journal, is try and explore, okay, from a gender perspective, what are the themes that are happening or taking place in these family mediations, right? The next thing is that we talked about, right? And I think Zishan was talking about that Pennsylvania clinic, right, Zishan? And so from a clinic perspective, right, that brings us to trainings, right? So then we should look at from a research perspective कि हमारी केस स्टडीज क्या हैं, राइट? जो हम केस स्टडीज प्रिपेयर कर रहे हैं लोगों को सिखाने के लिए, वो कितने जेंडर सेंसिटिव हैं, कितना रेस सेंसिटिव है, कितनी एज सेंसिटिव है, राइट? कितने केसेस हैं जब हम ये कंडक्ट कर रहे हैं, तो हमारी फैसिलिटी जहां हम ये कंडक्ट कर रहे हैं, वो जो ज़ईफ औरत है जो मीडिएटर बनना चाह रही है, she's 60 years old and but she wants to be a mediator. How accessible is the facility? How accessible? How much does she see herself in those role plays that you have made, right? That's about recognizing and doing something about it, right? So that's part of the clinic, that's part of training. And equally, who's training, right? What's your training mix? And these are research points. These are research points because what happens is that once you have trainers who are women who are training, the expectation becomes that, later on they will take on the profession of mediation and they will become successful mediators. But at least in the United Kingdom, what's being seen is that you have less women who are becoming mediators. They pass through the process, but there are fewer mediators that are women. The other thing that is remarkable in this field is that there are also fewer young people who are mediators. So, when you are going through that mediation clinic, the idea of getting those mediation cases, right? Because let's say if you're a mediator and you don't get cases, that's quite disheartening. And so the question becomes, how do you get those cases? And this then reminds me of that other Marush's article, right? Marush talked about med, arb, med. And so within this idea of med, arb, med, there's a very interesting gender issue. Because look, arbitration was developed after the Second World War because white male Caucasians, WASPs, thought that that's how they would conduct their dispute resolution. Women had very few roles in arbitration, and mediation actually has many more women participating as an ADR mechanism than men. So this is in itself a very interesting ADR research topic. कि पाकिस्तान की वेबसाइट्स जाएं, गूगल हो सकती हैं, देखिए भाई कितने पैनल्स में कितने मर्द हजरात ने आर्बिट्रेशन सेंटर खोला है और उसमें कितनी खवातीन है, तो देखिए आप, और कितने वो क्लिनिक्स कहाँ हैं जहाँ पर आप मीडिएशन सेंटर्स खोल रहे हैं, मीडिएशन इंस्टीट्यूट्स हैं, वहाँ पर तादाद क्या है वुमेन की, हाउ डज दैट प्ले आउट? सो दिस होल आइडिया ऑफ med art, even today in certain literature, is actually the difference of opinion on how of that space. dispute resolution जो है ना वो एक finite space है. Apart from how much money you can make out of arbitration and how much revenue you can generate from mediation, which is actually poles apart, it is still a space. And so what is the space? The space is, in this dispute resolution space, the men controlled arbitrators are much firmer and push harder, whereas the women, who are now much more a larger number in mediation, are still trying to push mediation, both men and women, but it's not getting the same status as arbitration. Apart from the revenue stream for law firms, the other aspect is that one of the pushback is that arbitration is still a male dominated field, or mediation जो है ना वो उसको it isn't given the same masculinity actually, and so there is an element of research in this whole idea of art med art, which is the more masculine form of dispute resolution. Is art is art the testosterone male, and the mediation is somehow less masculine or feminine? I mean, what's the battle? And if you Google this, you will find the literature. And these are fascinating areas of research, and also philosophy. So some research, right? Some research are very analytical, they're based on numbers, very scientific. But there is equal good research on philosophy, on jurisprudential points, on gender, which can be really constructive and help us recognize. Because remember, the idea of improvement, like I said, the idea of anti-racist is recognizing there is something wrong and then working to resolve it, but not just for yourself. So it's just simply recognizing मैंने सुन लिया, मैं खुश हूँ, अब मुझे जरा सी मैं समझ गया हूँ is not enough, but actually doing something to make the world a better place. So these are some of my ideas on potential areas of research. There were some examples as well, but I think I've gone way over time. I was given 15 minutes. I see my stopwatch at 26. So I apologize for taking too long, for being so fast, for being so quick. And thank you for inviting me. I hope that these points gave some nice framework of areas to study in mediation. Thank you, and back to you,
No.
Aisha.
Thank you so much. And yes, your stopwatch might be telling you that it's 26 minutes, but seriously, I was particularly so engrossed in your talk that I couldn't even look at the time, that we are above the time. And such a pertinent points you have taken, and yes, very rightly said that the gender aspect is missing from the research, and even we were not touching that point, though we are all a women law school. I think gender sensitivity, when you talk about gender sensitivity, I was just thinking that it should not only be a part of mediation, but it should be it should be made part of the law LLB curriculum, and there has to be one subject where we should talk about gender sensitivity. I am it was an honor to have you here, and seriously, we really get a wonderful insight into this new concepts, not new but new for us, and the students probably having a lot of new ideas. And yes, I could see in a chat that everybody is like thanking you for a lot of things. There are so many questions, and I am just going to take one or two because we are above the time. As somebody has actually asked, and I was looking for that, that what are the demerits of mediation? Why people are not adhering to mediation? That was one of the questions somebody actually posted in chat box. So Jawad Sahab, if you would like to comment on it, that why people are not adhering to mediation.
I think, thank you, Aisha. I think some of the points were well highlighted by Zishan, right? Zishan, I hope I've got the name right? Is Zishan. And so that's it, right? To summarize what Zishan said was that, it can actually add to your revenue stream, but it seems to be a threat to lawyers thinking that their income will be adversely affected by it. But there is another aspect to it, which is something that I shared in the chat box, and I'll just quickly elaborate. A lot of lawyers say कि देखिए access to justice जो है ना, जो सबसे गरीब तबका है उसके लिए पहले ही मुश्किल होता है कि वो कोर्ट पहुंचे, और जब वो कोर्ट पहुंचता है और अब वो आप उसको ये कहते हैं अपने वकील किया, उसको लाख 2 लाख दिया छोटे कोर्ट में, गरीब आदमी का केस है वो, उसके लिए तो 50,000 40,000 भी ज्यादा होते हैं। उसके ऊपर वकील ये कह दे कि भाई वो हमें तो वहां जाना है तो मैं तो इसकी खर्ची लूंगा, तो लिहाजा मुझे 5-10 हजार और दे दो। So that to a lot of lawyers at the lowest level is an addition to the cost. So एक तो cost हो गई वो सूट फाइल करने की, वो लॉयर की, अब उसके ऊपर आपने ऐड कर दी छोटी सी कॉस्ट है कि आप जो है जाइए और मीडिएट करें। अब इस लिहाज से जो जुडिशरी एटलीस्ट सिंध में है वो कहती है कि ठीक है जी हम आपसे पैसे नहीं लेंगे, तो वो इस वक्त जो सिंध में जुडिशरी काम कर रही है वो मीडिएशन फ्री ऑफ कॉस्ट है, मगर दैट स्टिल डजंट स्टॉप द लॉयर, because the idea is, since people are not aware of mediation, the idea is the party would like to have the lawyer accompanied to the mediation, so it still adds to the cost of mediation. So that's one element. Another element which is playing havoc in Pakistan, and again this is an access to justice issue, is there are some crazy things that happen in this country. And so sometimes the litigation is frivolous, but it's frivolous because, there's really nowhere else to go. And so when you are really stuck and there is really no place to go but the adalat, and the judge sees it and says, खुदाया ये केस यहाँ कैसे आया, but at the same time realizes कि ये आदमी और जाए तो कहाँ जाए, हर तरफ से सरकार ने इसके एवेन्यूज ही ब्लॉक कर दिए, तो ये यहाँ आ गया है, जबकि मेरा कोई काम नहीं है यहाँ कुछ करने का। तो फिर वहां पर आप आ जाते हैं तो फ्रिवलस लिटिगेशन के दरवाजे भी खुल जाते हैं, क्योंकि देयर इज नो चेक एंड बैलेंस एट द डोर ऑफ एंट्री टू अ लिटिगेशन. So unless there is a cost to frivolous litigation, and this is a very hard question, then there is no opportunity cost to mediate. Because look, if I go into litigation and I keep it pending for 5-6 years, I will get a great bargaining position. And I don't need to do anything but drag the 6 years out and get my solution. If I'm not really motivated to solve my problem, I will not mediate. So people don't mediate. They go into courts, they get an injunction, and then they disappear. And they play with time that person will come to the negotiation table and mediate and settle. Whereas mediation says that, that interim injunction, it expects that interim injunction will be decided in no time at all. And the minute it's decided, that other party who's got that ex-party injunction will lose his position of bargaining. So guess what? You better rush in, you solve the problem before you lose the injunction, because otherwise you'll lose everything. And so there is more motivation in that kind of system. In our system, there's no motivation, there's no cost for frivolous litigation. Sometimes lawyers think that you're adding a cost by adding mediation. And so those are some of the things that are stopping mediation. And then finally, judges need to be alert on cases that are suitable for mediation. So, not everything is suitable for mediation. If there's something that's based purely rights-based, right? So what is mediation? It's not, it's needs and interests. मगर अगर किसी के साथ ज्यादती हो, किसी के साथ गलती हो, तो फिर तो वो केस नहीं जाएगा। और कभी कभार हमारे पास ऐसे भी केसेस आ जाते हैं जिनका ताल्लुक कोर्ट में सेटल होना है, मीडिएशन में नहीं।
Very true, very true. You're right. I think there are many questions which you have already answered. Mr. Zishan has already answered during the talk, because a lot of students have just asked that how, that is it possible to have mediation commercial conflicts? Yes, it is. Mediation is possible, almost in all the cases. Somebody has also asked that is mediation possible in criminal cases?
Yeah. So the first one is commercial cases. I've done international mediations, 2 of them. They were both out of Lahore, interestingly. And what's great about Lahore, life works in strange ways. What's interesting is ये जो आजकल खास तौर पे ये जो I don't know Kinnaird का क्या course है, but a lot of lawyers go and become barristers. तो हुआ ये कि मेरा एक केस था, उसमें बैरिस्टर, and it was a woman barrister who was involved on the other side. And I knew that a woman barrister and a barrister, generally speaking, would be familiar with mediation. So I said, ठीक है, let's take a chance. बोलो भाई, mediation करोगे? And she said yes. And so out of the Lahore High Court in appeal, because it was the second round, they had lost on the trial side, we had a mediation. It was very international. My client was Japanese. The party was based in Lahore. The Japanese flew to Thailand. The Pakistani flew to Bangkok. We had a mediation. The mediator was an Irishman from Hong Kong, and we settled. And when we settled, all we did was, it was a confidential process, and we agreed on the terms of the application for withdrawal of the suit, the appeal, and we filed it, and the matter was settled. So this idea of, where do you get your statistics when you're looking at mediation? That's a big question, because of the fact that everything is confidential. It's a big issue when you're doing research in mediation. Where are you going to get your metrics? Because most of those detailed metrics, because of the confidential nature of the process, are missing. And so then this becomes a research question in itself. How do you gauge the success of a mediation when the whole thing is draped around confidentiality, statistically speaking? So that's commercial mediation. So let's come to criminal mediation, right? So one of the reasons we got burnt down was in Karachi is because unlike the CPC, which has section 89A, CRPC has no equivalent section 89A. But CRPC has the concept of compoundable offense. So the idea came about कि भाई अगर compoundable offense हो सकता है, that means कि आप जो उसकी compounding nature है उसको mediate कर लें. And this is a concept which has been enshrined in this idea called restorative justice, right? So if you look at mediation, you Google restorative justice, there's a plethora of material there. And so what happened was that when criminal lawyers, क्योंकि देखिए सबसे ज्यादा पैसे जो कैश पेमेंट्स होती हैं वकालत में, वो क्रिमिनल साइड पे होती हैं. वहां पर जो छोटा वकील है वो कैश में पैसे कमा रहा होता है बेल एप्लीकेशंस के साथ. आपने क्या किया वहां पर, हमने कहा ठीक है भाई, ये सब कंपाउंडेबल ऑफेंस है, इसको जो है ना सीआरपीसी गुंजाइश देता है, इसको आप मीडिएट करना शुरू करें. तो हमने मीडिएट किए क्रिमिनल ऑफेंसेस जो कंपाउंडेबल थे. मगर जो वकला हजरात थे जिनकी कैश लिविंग डे टू डे थी कि बेल एप्लीकेशन फाइल करके पैसे कमाना, वो बेल ही नहीं हो पा रही थी, क्योंकि वो उससे पहले कि बेल एप्लीकेशन मूव हो, वो मामला केसीडीआर पे कंपाउंडेबल होने के लिए पहले ही पहुंच जाता था. तो बेल से पहले ही काम हो रहा था, वकील की इनकम स्ट्रीम पे इम्पैक्ट पड़ रहा था. तो वो वहां बहुत नाराजगी हो गई कि भाई ये क्या हो रहा है. So the short answer to your question is yes, you can mediate criminal offenses because they are compoundable, with those that are compoundable. The problem is that CRPC has no clause which says that you can send it to a third party. What it presupposes is that it should be a negotiation. It doesn't say that you can refer to a mediator, which section 89A says. And so this was actually decided by Justice Mushir Alam. And Mr. What's his name? Anwar Mansoor Khan was acting for the Sindh High Court Bar Association. He was the president. They filed a petition against this, that nahi ho sakti mediation. And Justice Mushir Alam, who was sitting there, and it was a full bench in the High Court, decided कि हाँ, CRPC में there is no equivalent provision of section 89A, and therefore you cannot refer a matter to the for mediation under criminal law. तो वहाँ ये सब मामला खत्म हो गया. And it's not a reported judgment, I think. It's just one of those things where the Sindh High Court Bar got this stay because they were trying, by that time the whole thing had already been burnt down. So it was just a fact to comply कि भाई उसको justify कर दो कि जो जलाया भुनाया सही था.
Thank you, Jawad Saab. Mr. Zishan has one comment and then we are going to call it a day. Mr.
I'll make it very quick. Just one thing, one food for thought for everybody listening to me right now. Do we need to rethink the idea of cost of litigation? as Jawad rightly pointed out, like it is so easy to go out in court and get a stay order, an interim injunction. And no offense to Judge Sahiba, but the judges will not see the balance of inconvenience. They would not see the irreparable loss. They would not see anything, and they would just grant a stay order in 5 minutes. Do we need to rethink the idea of cost of litigation? In US, the cost of litigation is so much that you would definitely think 100 times before going to court, and you would want to settle out of court, and you would want to hire a mediator, and still your cost will be nothing as compared to the litigation costs. But in Pakistan, you can hire a lawyer of 5,000 instead of a 5 lakh, and you can get the same stay order from civil court. um, and this is how we are going in court. And then after, as Jawad again rightly pointed out, that after that interim injunction, both parties, or the parties which has got the interim injunction, they would just disappear, and the other party who has the grievance, and I'm sorry, again, the court is not listening, then what will that party do? So this is one thing which obviously we can discuss in the next session in another topic. Yes.
Thank you so much. Yes, it was, you rightly pointed out that we need to rethink a lot of things as we are so much above the time. So I am going to say a quick thank note to everyone. Thank you so much. I am so indebted by your presence over here, our worthy speakers. And of course, as Mr. Jawad just said that, last minute I contacted him. But, it's such a great talk. Thank you so much, Zishan, Professor Manur, Ms. Uzma, our students. Thank you so much, everyone. And also, I am thankful to Nadir Hassan Law Department faculty, without whom I'm actually not able to work with, at multiple forums. And my students who have taken out their time, and such an interactive session we had today. And I look forward to have other sessions as well on, mediation or on ethics, or, we keep on doing certain activities to make a difference, which we really want to see in our legal fraternity. Thank you very much, everyone. Thank you. Have a good day.
Thank you. Thank you. Khuda Hafiz.
Khuda Hafiz.
Thank you.
Thank you.